Open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the Supplementary Budget Estimates. The Senate has referred to the committee the particulars of proposed expenditure for the 2024-25 for the portfolios of Home Affairs and Attorney General and other related documents. These supplementary budget estimates, proceedings and the outcomes to be heard today's estimates are from the Attorney General's portfolio. The committee has set 5 p.m. Thursday the 16th of January as the date by which questions on notice are to be returned. The committee has also decided that questions should be provided to the Secretariat by 5 p.m. Thursday the 5th of December. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of the evidence given to a committee, and such action may be treated by the Senate as contempt. It is also a contempt to give false or misleading evidence to the committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance for questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential, consists of advice to government, is not a statement that meets the requirements of the order. Instead, witnesses are required to provide some specific indication to the harm to the public interest that could result from the disclosure of the information or the document. I remind all senators that as we continue our work implementing the Set the Standard report, as Chair, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Officers called upon for the first time should answer a question should state their full name and position for the Hansard record, and witnesses should speak clearly into the microphone. Mobile phones should be switched off and turned to silent mode. I now welcome Senator the Honourable Murray Watt representing the Attorney General. I also call officers from the National Anti-Corruption Commission. Minister, would you like to make an opening statement?
Thanks, Chair.
And Mr Reid, would you like to make an opening statement before we go to questions?
I've provided a copy of an opening statement.
Okay, I think
a couple of hours
it's being
ago.
Provided. Thanks, Senator Shoebridge.
Okay. But I will pick up on a few points.
That would be great. Thank you,
Okay.
Mr Reid.
So in this statement I'm referring to operational outcomes, the issues of the NAC Inspector's Complaint Investigation Report, transparency and secrecy. I think probably the most important thing is to say that as of this weekend we will have been in operations for 17 months, so we're still a relatively new organisation. We have a large workload that we have underway at the moment with 38 preliminary investigations as part of the assessment process, 29 corruption investigations, including 6 joint investigations. We've finalised 1 joint investigation. We're overseeing or monitoring 19 investigations by other agencies. There's 5 matters before the courts and there's 558 matters pending assessment. And then what I'll probably do is just go back to the statement that I normally make when I've appeared, which is the Commission doesn't generally disclose information about the subject matter, status or progress of referrals or investigations, as to do so may prejudice operational activities or unfairly damage reputations. As a result, I'll not be in a position to answer questions on whether the Commission has received referrals about particular matters, except where this is already on the public record, nor comment on ongoing investigations. This will mean that I'll generally neither confirm nor deny the existence of a referral, to the Commission or of an investigation by the Commission about a particular matter. So they were the only things I wanted to raise.
Thanks, Mr Reid. We'll go to questions.
Yes.
Senator Scarr, you don't have any questions at the moment. Okay. Senator Shoebridge, you have the call.
Oh, thanks, Chair. Since you'll ask before the joint committee, the Joint Oversight Committee, can you give an update on what's happened in relation to your engagement, your hiring of an eminent person?
So the process of appointment is imminent. We're at a point where we should be able to announce in the not too distant future who the person will be, but at this point it's still a work in progress, but we're more advanced than probably we were even last Friday when we appeared before the Parliamentary Joint Committee on the National Anti-Corruption Commission.
All right. There have been multiple reports that former Solicitor General Justice Gleeson was in the mix for the appointment as an eminent person. Mm-hmm. Is it true that the former Solicitor General was in the mix?
So I suppose the answer to that is a bit longer than what you'd perhaps have hoped for, but the process of appointing a person to perform the independent reconsideration function is not straightforward. Because under the Act, the power of delegation is limited to staff members. So in any reconsideration of the referrals of a current staff member would not be seen to be independent of the process, which led to the original decision. So we needed to find an appropriate person who would be prepared to be appointed as a temporary staff member. Appointment as a temporary staff member is a function of myself as CEO, while the making of the delegation is a function of the Commissioner. So we sought the assistance of the Australian Government Solicitor in putting together a list of possible appropriate individuals that they believed would have the skills and independence to reconsider the robo-debt referrals, and whom the AGS engaged for complex work of this nature. A number were approached. It would not be appropriate to name the individuals involved. One of them, who indicated interest, was then the subject of further consideration and discussion. That person would have been very suitable in many ways. To expedite the process, I submitted a request for the necessary approval from the Australian Public Service Commissioner, which is around remuneration, to engage somebody for this role. But before the approval was given by the APSC, media reporting, which the Australian Government Solicitor had discovered, was raised with us. We then had a conference with the AGS senior and junior counsel that have been engaged to obtain advice about it. The advice was to the effect that while the risk of a challenge on grounds of apprehended bias succeeding seemed low, it could not be excluded, and it was not worth the risk that the independent delegate's decision could be challenged. We accepted that advice, and we therefore withdrew that application and pursued an alternative candidate for the appointment.
Mr. Reid, I asked you about former Solicitor General Justin Gleeson, and I'm understanding that's your answer to my question. Is that right?
So I think I've answered the question. Was the media reporting reviewed by you, Mr. Reid? Sorry, the media reporting
that you say led to the concerns.
Oh yes, yeah. So I was aware of it and viewed it, and was part of the discussion with the AGS and senior and junior counsel.
And was the media reporting reviewed by the Commissioner?
Yes, the Commissioner would have been aware of it.
And was the Commissioner, did you have discussions with the Commissioner about the appropriateness?
Well, we had a conference with the AGS and junior and senior counsel
The Commissioner was in that conference as
and
well?
he was in that conference.
Who else was in that conference?
The Deputy Commissioners.
Each of the Deputy Commissioners?
I think from memory, yes.
Who made the decision?
Well, the
Just let me
advice
finish the
came
question.
from AGS that they felt that whilst the risk of a challenge on grounds of apprehended bias succeeding seemed low, it couldn't be excluded and therefore it wasn't worth the risk of appointing.
Who made the decision? Did you make that decision as Chief Executive Officer, or did the Commissioner make that decision as the person
ultimately
who had
I'm the
power
one
to
that needed
delegate?
to appoint the person, and therefore, unless I was satisfied, nobody could force me to sign to appoint somebody. So
I'm not asking about who was forcing you or not forcing you.
No,
I don't know
saying
how the
nobody
organisation
could.
works in that regard.
Nobody could.
But I'm asking you who made the decision.
Well, ultimately, the decision would have been me having to appoint somebody, and based on the conference with AGS, Junior and Senior Counsel, other people in the room, it was decided that the risk was not
I'm
worth
trying to
taking.
get past the passive voice here.
Sorry?
I'm trying to get past the passive voice.
But I
Who
think
made
I've
the
answered
decision?
the question, which is I'm the person that would appoint the individual, and therefore, if I'm not satisfied that it is a sound decision, I'm not going to do it. And therefore, ultimately, you could say the decision is mine.
So you made the decision
Well,
not to appoint
because
the
I'm the
person.
one that would have to sign
No,
the paperwork.
I understand
so-
that if it got to the point where the person was put in front of you, you would have to make a decision one way or another.
Well, no,
Was
it's
there
not
let me finish, Mr. Reid. Was there an antecedent? Was there a decision made to withdraw this person?
Yes, there was.
Because that isn't necessarily your decision. Your
Well, it
decision
is
is whether or
because
not
it was me
your
that had put forward the advice to
Reid,
the Australian Public Service
Mr. Reid,
Commission.
it won't work for Hansard if you keep talking over the end of my question. Was a decision made to withdraw this person? Because that's not necessarily your decision. That may have been a combined decision of the Commissioner and yourself and the AGS. I understand you have you would have the decision to employ or not to employ, but it's not in front of you, then you don't have a decision to make. And I'm trying to work out what decision was made. Was it to withdraw this person? And if so, was that your decision? Was it the Commissioner's decision? Was it the AGS's decision? Or was it a joint decision?
So we got advice from the AGS with Junior and Senior Counsel, and it was agreed by the group that it was not, that we would not proceed further. I then withdrew the application that I'd put into the Australian Public Service Commissioner, and so that ceased the process because we couldn't have proceeded without that advice.
So it was a collective decision of the people in the meeting.
Well, there was an agreement amongst the group. So
You say
you can
agreement,
call
I
it a
say collective decision. Is there a difference that I should point to?
Senator Shivridge, it will also not assist Hansard if you keep speaking over Mr. Reid when he finishes his answers.
You say, you say agreement, I say collective decision. Is there a distinction here you're trying to draw, Mr. Reid?
Well, I think that there is, but maybe it's a subtlety of the English language. If a group agree to something, it doesn't mean it's necessarily a collective decision. It's not like cabinet or where you're bound by particular rules.
Right. Can you tell me the circumstances in which one of the key governance officers who had been advising you and others in relation to process and integrity matters left the agency recently?
So if we're talking about the material that appeared in the Saturday paper, and I'm certainly happy to talk about that.
Well, perhaps we could start with what was the position that was held by this person?
So there was no position as described in that article. So there was never there was never a Director of Governance, Risk and Reporting. There was a Director of Governance and a person that probably is who's being referred to here, but it's a bit unclear, was acting in the role of Director Governance. Their substantive position at the time was Assistant Director Governance and Performance, but the governance team included the Assistant Director of Integrity and Risk, which is a different person. So I think this is a conflation of two different components of that team.
So the person's substantive position was Assistant Director of Governance and Performance, but was acting up, I assume, as Director of Governance.
Yep, and they left in December of last year.
Right. Did they speak to you about why they were leaving?
No.
Did they? Are you aware of them having informed anybody in the organisation about why they were leaving?
They reported to a general manager, and the title of that general manager was the General Manager, Executive and Business Support, and that person had been, well, I'm not sure if they applied, but we went to the market and filled the role of Director Governance, and the current Director Governance started on the 11th of October last year. So this person that we think that is being referred to in the article remained in the organisation in their Assistant Director role until December, and then went to a different role within the public APS. So as far as I'm aware, there was no discussions either with the General Manager or the new Director Governance in relation to any of what appears to have been suggested there was issues about in the newspaper.
Well, the article reports the person as being at one point the acting Director of Governance.
So they were definitely, if it is that person, they were definitely acting Director.
And did they report to you in that capacity?
No. Well, everybody reports to me apart from the other statutory office holders, but this person reported through a General Manager, Band 1, who then reported to me. So it was two steps down in the organisation.
Did the acting Director, either in her substantive or acting position, raise concerns about the circumstances in which Commissioner Brereton brought his associate over?
No. No. That was never raised, as far as I'm aware, by anyone.
You say not raised by this person and not raised by anybody?
No, not that I'm aware of.
Can you describe the circumstances in which Commissioner Brereton's associate was engaged? And was the initial engagement, was there an open process?
So there was a vacancy of the executive assistant position. We provided these answers, by the way, to the Saturday paper, and some of them they sort of partly picked up. But so at the beginning, the 1st of July 2023, there was a vacancy of the executive assistant position in the National Anti-Corruption Commission, and in conformity with the Public Service Act 1999, the position was initially filled on a non-ongoing basis, and then following that there was an externally advertised competitive merit-based process to fill the role permanently.
Right. Can you provide to the committee on notice the external advertising or however that was externally reported, the vacancy?
Yep, happy to.
And if you can provide any details on whether there were any other applicants for the position. Were there other applicants?
Yeah, there were other applicants.
And who?
It was only a relatively small number from memory, but.
And who was in the assessment panel to determine the?
So the assessment panel comprised the General Manager of Legal, my executive officer, and the head of our people team, which is the HR team.
Do you know if it was a unanimous?
It was a unanimous decision. I approved the outcome as I didn't delegate it to anybody.
There are concerns also raised that there were misconceptions inside the NAC about the reporting requirements for Oz tender purposes, that there was a misapprehension that the reporting requirement was $100,000 when indeed it was $10,000. Is that true?
I'm not aware of that. I mean, it's an interesting concept because, of course, you've got the Murray motion as at 100,000, I think, isn't it? And Oz tender at 10. I'm not aware that there was any issues, but the General Manager of Enabling Services, George Philip DeVette, might wish to jump in.
Before we go there, and I would appreciate your assistance, Mr. DeWitt, have you made any inquiries about this, Mr. Reid? I mean, ultimately, you're the senior officer. You, as you say, everybody reports to you.
That's true.
I mean, this was published a week ago.
Yeah.
In the time since then, have you made any inquiries about whether or not this was happening?
There's been a discussion about it because I was a bit, to use a term, gobsmacked that had been raised because it's not something that I ever remember being brought to my attention. It's possible, but I certainly don't have any memory of it.
Well, I mean, we're only talking in the last 5 days.
I know,
Mr.
I didn't
Reid.
mean...
So
sorry, in terms of it ever having been raised apart from in the Saturday paper. So when it emerged in the Saturday paper, it seemed to be one of those things from left field that was, incredible, perhaps I'd say, and I was a bit incredulous about it because it had never been raised with me that I'm aware of.
Well, so I have 2 questions. One, have you made investigations since then? It seems to me the answer is no. You haven't made investigations.
Well, no, I've had a discussion with the General Manager of Enabling Services, which is Finance, HR and IT, about his memory or knowledge of that, and that's why I've suggested that you might want to have him add to this.
Right. Have you checked to see what guidance is given to your staff about reporting obligations?
Well, yes. I mean, and the guidance is quite clear.
And it is? What is the guidance?
Well, there's the accountable authority instructions and delegations that exist. There may be others. GP?
Yep, so Senator George Philip DeVette, General Manager, Enabling Services. So if I could, I'll just deal with the part of your previous question in relation to the advertising of the Executive Assistant to the Commissioner role. So it was released to the market on the 12th of September, closed on the 26th of September, and the vacancy notice reference for that was 0747862, and that's able to be viewed on the Gazette through the closed notices. If I go to your...
But just to be clear, Mr. DeWitt, that that doesn't answer my question, which is for the provision of the relevant advertising and other materials.
And we can provide that. There's no issue with that.
To your question about procurement, Senator, so as Mr. Reid alludes to, the reality of the way that the Commission undertakes its procurements is entirely consistent with the Commonwealth procurement framework. Our internal guidance reflects that. And to the point Mr. Reid made about a level of surprise, if you look at the way that we're reporting on our contractual obligations, they're consistent with AUSTender Gazettal within 42 days. The thing that I would say was the case in the early days of the NAC and the transition from ACLI to that was a bit of recidivism in relation to how quickly that got reported. But we undertake all of the required reporting and internal approvals consistent with the CPRs, and our internal guidance and processes reflects that. So that was a genuine surprise seeing that in the article.
All right. Perhaps you can, on notice, provide what, if any, formal documents or notifications went to your procurement staff that shows that the misapprehension that's included in the Saturday paper article was indeed a misapprehension and contrary to guidance that had been given, if you say this guidance has been given. You provide that on notice, and including when that guidance was given in writing about the AUSTender threshold.
Yep.
Has it been given in writing?
I'll take that on notice, Senator. My understanding again is that we, again, the $10,000, anything above $10,000 gets gazetted as appropriate on AUSTender, and there haven't been any exceptions to that.
Well, you see, Mr. Reid, you're the Chief Executive Officer, and I would have thought that you would have, having read this, have asked your team to show you where that guidance had been provided or that direction had been provided in writing to your staff. You haven't done that yet.
Well, the General Manager and I discussed it, and we were both surprised that it had even been suggested, because there's no evidence to that effect.
Well,
There's absolutely
perhaps
no
you can
evidence to that
review,
effect.
Mr. Reid, you can review whatever written directions are given to your staff.
Happy
You
to.
haven't done that yet. Is that my understanding?
Well, because there was no evidence that there was a problem.
So the concerns that were raised, and I'll just read what was in the Saturday paper. The Saturday paper understands that there were other misconceptions about the procurement rules, including one where staff mistakenly believed the reporting threshold for Commonwealth AUSTender contracts was $100,000 when it is in fact $10,000. You had so little regard to that you didn't check to see whether or not
Well, I did.
there was
I
any
had a
veracity.
conversation with the General Manager of Enabling Services, and both of us were surprised that that would even come out, because there's no evidence of that having occurred.
You see, my assumption is there would be a curiosity in the NAC if concerns are raised without maybe a statutory declaration, without that, there would be a curiosity in the NAC to make sure that these things are at least had at least a rudimentary investigation. But what you did was you had a chat with Mr. DeWitt, as you described, and that's it.
Yeah, because I don't think it warranted anything further, given that there is no evidence that it was the case. So,
Senator, if I again could add to Mr. Reid's testimony, I'm referring to one of the documents that we will provide you on notice, and it's our standard 23.3 PGP8 section 23.3 expenditure approval for procurements greater than 80,000, and this is traversed between 10 to 80,000. There is a provision in the documentation and the guidance that says, note, in order to meet reporting requirements, all arrangements, including variations at or above $10,000 GST inclusive, must be reported on AUSTender.
And when was that document produced, and when was it sent to your staff?
Understanding that as part of the transitional arrangements from ACLI to the NAC, we adopted a lot of the interim policies as the commencing policies for the NAC. This policy was originally issued on the 30th of April 2015.
And you'll provide on notice when that was sent to the relevant procurement staff?
Yep.
And if it was operative at the
Yes, I
time?
know.
Yep. You provided answers in notice to another inquiry, the Parliamentary Joint Committee, about how conflicts of interest are dealt with, and that made it clear, I've reviewed those documents, that there's no longer an obligation to put in a written document about a conflict of interest.
in relation to the NAC senior officer, what's the P? Panel, sorry. Just forgot the word. So the NSAP...
I know what you're talking about, Mr. Reid, that panel of senior officers who
That's
review
right.
matters.
Yeah, and the terms of reference for it have been amended following the inspector's report.
And that's to remove the need for a written document.
Well, sorry, it was amended to remove the need for the written document before the inspector's report. It's now subsequently been amended in terms of when a conflict is declared, what that actually means, which is that the officer involved should not remain in the room for the discussion.
So there were three versions of the relevant provisions. There was the initial one which required a written conflict of interest to be lodged. That wasn't complied with.
Because the decision was taken early on that it was better to do it in the room.
Oh, when was that decision made?
Well, I think we've already got that on notice for...
I don't think so.
Is it on notice or is it...
But my understanding of the evidence was that far from it being a decision, it's just the practice evolved, which was contrary to the written provisions. But Perhaps, Mr Reid, you can clarify this on notice, which is accurate.
Yeah,
Your position
my,
here that
my
a decision
memory
was
was
made.
it was September or October last year that the actual terms of reference were changed so that it was done in the room. But I'm happy to take that on notice.
But if there was such a decision as you've just suggested, can you provide on notice who made the decision and when the decision was made?
Well, it was an agreement of the NSAP.
Or when that agreement?
Yeah, and I
Agreement,
think
decision.
it was in September or October.
All right. And was that minuted?
It would have been.
Or can you provide the minutes as well?
Okay.
Was that yes? So there was the original one which required a written conflict of interest. That wasn't complied with. Then your evidence now is there was an agreement amongst that group to amend the conflict of interest reporting requirements so that they were, or rather me put words in your mouth, what was the amendment that was agreed to?
So that was an amendment that at the beginning of each meeting, or in advance of the meeting, but at the beginning of each meeting, any declarations of conflicts were made and minuted. So I think we had this brief discussion at the PJC NAC about the fact that they are minuted and had been minuted since the beginning. It's just that the terms of reference had indicated the form was meant to be filled out and pre-lodged, and that was seen as being too complex. It was an Ackley hangover, if you want to call it that. And for the number of matters that we were dealing with at the NSAP, it was not going to be an effective way of trying to manage the variety of conflicts that could be there. So it became something that was on the agenda at the beginning of the meeting, individuals nominating whether they had conflicts or not, them being recorded in the minutes, and therefore there's a record.
All right. So you say that was some agreement that was reached. When did you say that was reached?
My memory is it was either September or October
And then
of 2023.
Since then there's been some other alteration.
Subsequent to the inspector's report, it's now been further amended to ensure that if there are conflicts, people leave the room.
If there are conflicts?
People don't stay in the meeting.
All right. And it's that last version that you've provided on notice to the PJ NAC, is that right?
I'm not sure. I'd have to...
Well, perhaps for clarity, you might provide that, whatever the current...
I'll go back and check.
Given the oral reporting by Commissioner Brereton in the Robodebt matter...
And written.
The oral and written had multiple variations of the nature of the conflict of interest. You don't think that history would suggest a clear written statement about the conflict of interest would be an integrity measure in the NAC?
Well, he had put forward clear written statements about the potential conflicts that he had.
And they differed with his oral statements.
And
multiple versions.
And he made...
I've asked you already to not interrupt Mr Reid when he's answering your question.
And he made declarations at meetings that were then minuted. So there was certainly no issue from my perspective in terms of him being upfront about the fact that he had conflicts in a variety of places potentially. But anyway, so I don't think there was any lack of knowledge amongst anybody that was participating in those discussions that he had advised of conflicts.
Well, there are now 4 different versions that Commissioner Brereton gave about his conflict of interest during the process, and there's a 5th version that's found on your website as a further clarification. We now have 5 different versions. You don't think that even just a sensible review of that would suggest that that's not a particularly good process and that there's actually a powerful reason to have one considered written, just for the good of the NAC, given what's happened in this case?
I mean, that might be your view, but I don't think that from the National Anti-Corruption Commission's perspective there was any doubt about conflicts existing. It was how they then were managed, which is potentially where the issues have emerged.
So which of the 5 versions that Commissioner Brereton has given about his conflict of interest should we rely upon? The first one, the second one, the third one, the fourth one, or the fifth one?
And
Which
I
is the
can
one we
see that
should
you're
rely
trying to separate these as being different, and they're not. So, and I think he explained that quite clearly at the PJC-NAC public hearing, and it's now in the Hansard, so I'd probably refer you back to that. Otherwise, we're going to go backwards and forwards over issues that I think he has given his own view about publicly.
Shoebridge, sorry, Mr. Reid, you finished your answer?
Yeah.
I have a very short block of questions to ask. I was just trying to see if you were able to finish your block, but otherwise we can come back to you. We've got
I actually think your timing is immaculate, Chair.
Is it? Funny that. Well, I might just ask a couple of questions I have in relation to one of the other roles that the NAC plays, apart from its investigation function, is around educating the public service, around corruption and risks, and ensuring that they are conducting themselves appropriately at all times. Can you tell us about that function, that education function, and what activities the NAC has taken in the last 18 months?
So it's a combined area of corruption prevention and education is the way that we put it together. And so it started early. I mean, in fact, it started before the NAC with information being provided out to APS agencies about the role of the NAC. But as soon as the National Anti-Corruption Commission started, in fact, on the first business day, the 3rd of July, the Commissioner did an opening of the Commission and explained how the Commission would operate. And from that point onwards, including in the corruption prevention and education area, and from that point onward, the Commission has actively undertaken a series of briefings. There were 125, I think it was, in the last financial year, and we're up to something in the order of 47 in the current financial year. And that included coming to Parliament and briefing the party rooms and him standing in front of the party rooms to explain the role of the Commission. But it went way beyond that, because the Deputy Commissioners as well and a number of the General Managers have an active program of speaking engagements. Now, we're doing them in a more targeted way now than they started with anybody coming through the door. We would try and fulfil the requests to undertake speaking engagements. Now we're targeting them more to the areas that we believe require more of an understanding of the issues surrounding corruption and what things that those organisations can do to try and reduce the risk of corruption. And then in December last year, we introduced that there were going to be 3 focus areas that corruption prevention and education thematic areas that would be rolled out over this financial year, and that was about conflicts of interest, ethical decision making, which linked directly to the recommendations of the Royal Commission report, and corruption risks and vulnerabilities in the context of elections, given that there is risks associated with elections. I'll give you an example, such as the weaponising of an organisation like this during elections. And so those 3 thematic areas of work that is ongoing within the organisation, none of them, they've been referred to in many of the presentations. None of them are finalised at this point, but we're drawing them towards finality. And so they were you've got these ongoing presentations to various parts of the APS, but also to the public, in particular organisational professional association settings. we've got the 3 thematic areas that we're working on. We've issued fact sheets around some elements of the work we're doing, including about dealing with contractors. We've launched and closed now the initial Commonwealth Integrity Service, a survey of all staff agencies within the jurisdiction, and that went out to 278,406 individuals and got a response rate of 21%. We're collating the outcomes of that survey, and we have said publicly that we will provide that information to agencies, but also publish a Australian Government public sector report in relation to that, which will have de-identified information in it. So that's another corruption prevention education function, and that will inform work that we will take on.
Thank you. Do you... so you've had your own survey. Do you take, or is it something that you would consider each agency has its own employee survey, and there are questions in there, I think, about integrity and transparency and perhaps even corrupt conduct?
There's questions about the activity that an individual may perceive to be related to corrupt activities.
And this is a generalisation, but I think more often than not, when those questions are broken down, it often relates to recruitment processes rather than other types of corruption. But I was wondering if that's something that you will collate or look at as part of your education program.
Yeah, so we're actually getting the same information potentially through the referral processes because that area of recruitment, nepotism, is one of the 3 or 4 areas that are coming up consistently within the referrals. It's hard with the APSC census because some, at a high level, you'll get an understanding of the sort of nature of what it is that's coming out. For smaller agencies, you may not get any information about what the perception was, apart from the fact that there was a perception. Okay. And so I think our integrity survey is trying to help close that gap. And time will tell. We're still collating it, so when we release it, we'll probably have more to say about it at that point.
And you've referenced this, but of the referrals that you receive, 3,190 so far, I think. Yeah,
so in the last financial year, and there's been subsequently another, sorry, let's go back to my figures, a further 1,051 referrals since the 1st of July.
So you do, and most of those are voluntary referrals. You use,
that's right.
You use that intelligence to inform your education work about the types of referrals that you're receiving.
It's predominantly the matters when they pass the triage stage, which is the initial phase of where we decide whether to take further action or not. And invariably that's because it may not be an identifiable public official or an identifiable corruption issue. And then things move into the assessment process. The assessment process, which also decides whether or not we're going to investigate a matter or not, there's a lot of corruption prevention education messages that get taken out of that process, because whilst we may not decide to investigate a matter, there will certainly be areas that you can see warrant educative work. And so we're trying to inform our corruption prevention education function coming out of real issues that are emerging through that process. But at the same time, obviously, you know, the overarching APSC census will also give us input, but our survey hopefully will give us more fine detail information that we can rely on as well.
Thanks, Mr. Reid. I do note the time. I think the last thing I wanted to ask is how have you found the willingness of the APS to engage with the NAC on this work?
I think we'd have to say that it's improving.
That's good.
I think, you know, to begin with, we got a lot of voluntary referrals, and at times you get them from an agency rather than being a mandatory referral. The mandatory referrals are increasing in number. Our both corruption prevention function, which is doing a lot of interaction with APS agencies, but also our assessment area, which is doing a lot of outreach to agencies when matters come in, is creating, I think, a more clarity around the issues surrounding what does it mean to be a mandatory reporter, and we've put out guidance on that as well, but also to try and remove some of the fear factor that might be there from people that assume, because I think there is a belief in the community that any matter coming to us is going to be investigated, and that's not the case. And that's the same in integrity agencies around Australia. But there is a sense at times that is meaning that there will be an investigation. So there's an assessment done, but most matters don't warrant investigation.
Thank you, Mr. Reid. Senator Shoebridge, do you have any more questions?
No, I don't.
Well, thank you. That's all the questions we have for you this evening, Mr. Reid and team. So thank you very much for your appearance. I now call officers from the Administrative Review Tribunal, formerly the Administrative Appeals Tribunal. Might just suspend the broadcast for a short period of time and while we get a change at the time. Just in a second. Thank you very much. Thank you. I now welcome officers from the Administrative Review Tribunal. Welcome, President. Good to see you. Would you like to make an opening statement before we go to questions?
I haven't got a promotion yet. I'm still the registrar.
Oh, sorry. Apologies. It's the last day of sitting. I'm reading from the notes.
Michael Hawkins, CEO and Principal Registrar of the Administrative Review Tribunal. I believe my office has provided an opening statement to you, but if you don't mind, Chair, could I just refer to a couple of key paragraphs?
I think that would be great.
Just to save a little bit of time, because it is our first appearance before you as the ART, so it'd be nice to acknowledge that.
Thank you.
As you know, we commenced operations on the 14th of October 2024. I'd just like to acknowledge that it's a credit to the commitment and tireless efforts of many people since the announcement of a new tribunal, notably the staff and members and the leadership team of the former Administrative Appeals Tribunal, as well as staff of the Attorney General's Department and various other agencies. I want to publicly acknowledge these efforts and thank everyone who contributed to making the establishment of the Administrative Review Tribunal a reality. I particularly want to acknowledge our staff, the vast majority of whom have undertaken transition tasks at the same time as continuing on with their day jobs of the business as usual activities of the Tribunal. And of course I do want to acknowledge this committee and the Parliament for the role it played in the rigorous examination of the legislation and its ultimate passage in a very timely fashion. Thank you.
Thanks very much. Senator Scott, we'll head to you.
Thank you. And thank you, Registrar, and congratulations on your appointment as Registrar. And also congratulations to you, Mr. Crew, as well, in terms of your ongoing role. And I acknowledge the reference in your opening statement to the significant workload that many of the staff of the AAT, now the ART, had to endure, had to discharge both transitional tasks whilst also doing their day job. So thank you to all of those members. I do note, Registrar, the opening statement seems to have is that a new logo for the Administrative Review Tribunal?
It is indeed, yeah.
So what's the, is it meant to symbolise anything in particular, the different colours,
I'm sure our marketing people to put it together can give you quite an explanation, but it's stylistic.
Mr. Crew?
Jamie Crew, Chief Operating Officer. Senator Scarr, I think you'll see the fulcrum in the middle of the logo there to represent justice, and the pathways, the ribbons in and out represent the pathways in and out of the tribunal.
I can't see a fulcrum.
In white.
On white.
The middle of the ribbons.
In the middle of the ribbons.
The white on white.
So Mr. Crew, this is estimates, so you're going to expect my next question. What was the cost to develop this new logo?
So the exact cost of the logo, I'll take on notice, but it was about $80,000.
$80,000?
The whole lot, not just the logo, Senator, but the whole rebranding for the tribunal. In terms of all of the material that we use for letterheads, the logo itself. So it was around $80,000 for the entire rebrand of the organisation.
Okay, thanks. Whilst we're on the issue of costs, can I ask you, there were 2 ceremonial sittings, as I understand it, in conjunction with the establishment of the ART. One was held in Sydney and the other in Melbourne. Do you have figures with respect to the costs that were incurred in relation to those ceremonial sittings?
No, I'd have to take those on notice, Senator, sorry.
Take those on notice, Senator. I don't have the exact cost. So, do
you have a ballpark figure?
The ceremonial sittings themselves weren't particularly expensive. They were sittings where a few staff travelled,
right,
and a few members travelled, but it wasn't a significant cost for the ceremonial sittings. But I'll take on notice the exact amount, provide that.
Okay, if you can, and if you can provide us a bit of a breakdown with respect to the costs. What was the cost to refurbish the President's Chambers in Melbourne?
Senator, that was work was done at appointment of the President a little while ago. I'll have to take the exact cost, but there was some minor shelving work undertaken at that time in relation to a conference room and a conference table. And I think that is the extent of the works that were undertaken, but I will take on notice the exact cost of that fit out.
Okay, if you could, and you talked about the shelving. Does that include new library lining in a meeting room, presumably?
So there was some shelving in the meeting room.
Yeah.
That was also in his office as well, and the meeting table. So it was minor works. It wasn't a significant cost, but I will take on notice the exact cost.
Okay. Was there any furniture transported from other offices to the President's newly refurbished chambers in Melbourne?
So there was some furniture moved from the previous President's office to the new President's office.
And what was that furniture?
I think there were some chairs. I would have to look exactly what was transported, Senator, but I think there were a few chairs transported and lounges. No, the lounges are still there. Sorry. I will have to check, Senator, but definitely a few chairs.
Include that in the cost.
So it was over a year ago.
So essentially all the costs associated with establishment of the President's office, and with a relevant breakdown, that would be most helpful. Okay.
Yeah, sorry, Senator, it was over a year ago, so in the previous financial year, so out of mind.
That's okay. No problem. Registrar, what's the morale like at the ART at the moment? So obviously you've gone through this huge change. As we've asked questions of you over the last few years, you were, as you intimated in your opening comments, you were keen for the process to be completed as soon as possible, legislative process, so that you could turn the page on the next chapter. How would you describe the morale at the tribunal as we're sitting here today?
Senator, I think I've always reported to this committee that I could look at it from two perspectives. From the staff, there was always anticipation, a high degree of excitement, and looking forward to getting on with the new tribunal. From the members' perspective, there was probably some nervousness about the uncertainty of whether they would be reappointed in the reappointment process. I think now that we are in the new tribunal, there's a sense of relief amongst all those that have been appointed as members. Generally, they all have their sleeves wound up and shoulder to the wheel type thing. They're getting on with their cases. The staff, I can say, we are still somewhat understaffed. We just haven't been able to recruit as quickly as we would have liked to. We're very enthusiastic about the powers that you've given registrars to be able to proceed with matters more quickly, not so much to keep matters away from members, but be able to deal with some types of matters administratively and to really hand to members matters that need to be heard and to be dealt with substantively. So we're still going through. That is a slow process where we recruit registrars, educate them about the full extent of powers that we have. So I'm hoping that we'll be, I guess, in full swing with those registrar powers early in the new year. But I think the overall morale in the tribunal at present is quite positive.
Okay. You talked about understaffing. What are the particular areas in which you're suffering from understaffing at the moment?
We need about 40 to 50 registrars and about 40 to 50 member support officers.
So it begs the question in my mind as to, was this an area where you were understaffed in your previous guise as the AAT, or were there a number of people who took the opportunity to exit with the transition from AAT to ART?
Senator, I think it's fair to say that in the former tribunal we were underfunded and consequently understaffed, and certainly running 3 years of deficits as we did, I did have to take a hard line with staffing levels. Now that we are funded in a demand-driven funding model, we are able to now properly staff the tribunal, and that does require us recruiting additional staff.
Okay, thank you. Can you confirm, Registrar, that the President intervened to block any transfer of personal leave for members transitioning from the AAT to the ART?
Sorry, what did he do?
Could you confirm whether or not the President intervened to block the transfer of personal leave which was accrued by members of the AAT when they transferred to the ART?
Yeah, the President has a view that personal leave is discretionary to the President. He has a discretion as to whether to grant personal leave. Personal leave in the AAT was recorded on the HR system, Orion, as notional. So there wasn't actually accrued leave as such, it was only notional leave. And it was at the President's discretion whether that leave be granted.
Okay, so you've responded to the question in terms of the President's powers and his discretion, but the question I asked was, what was his motivation in doing that? Why did he exercise those powers?
I'm not sure that he has exercised a broad power to deny. We haven't. Well, let me make it as easy as possible for you. What
actions has the President done or not done in relation to the transfer of personal leave accrued by members, you're saying potentially on a notional basis, from their time as members of the AAT to them becoming members of the ART. From your perspective, what steps has the President done in relation to management of that issue?
My understanding is we have not transitioned any personal leave across to the new tribunal, as that was only notional leave.
Okay. Have any members raised that issue with you?
Not with me, no.
Have any members raised that issue with the President?
I don't know. I'd have to raise that. I'd have to ask the President.
Okay. So are you aware of any dissatisfaction amongst members in relation to that decision by the President?
No, look, I'm aware of a situation where a member was unhappy with the application of the President's discretion to personal leave within the AAT, but I'm not aware of circumstances of dissatisfaction of the transfer, so to speak, of notional leave to the new tribunal.
Okay, so your testimony is there was only, well, I don't want to verbal you, I'll give you, as I understand your evidence, you're saying you were only aware of one instance under
in
the guise of the
AAT,
where the existing president of the ART, in his then capacity as president of the AAT, decided not to exercise his discretion to...
No, didn't treat the notional leave as automatic entitlement to leave, rather enforced his, not enforced, but exercised his power to grant leave as a discretion. He questioned whether the grounds on which leave might be granted.
Right, and what happened ultimately? Was the leave granted?
Yes, it was.
It was, okay. Do you know what the reasons for the leave were without...
Oh, I shouldn't comment on a member's personal requests.
Okay. Okay. What honorifics does the tribunal permit members to use when their names and titles are put up, presumably on the website and also in the course of proceedings?
In the course of signing a decision, they'll be identified as a member and their surname. If they are if they're a silk or a senior counsel, they may use that. Otherwise, no honorifics. If they have the same surname, if two members have the same surname, then we'll also adopt an initial. And should they have the same initial, then we'll use their full name.
Okay. So is the effect of that policy that a member who's potentially served in the military and has an honorific arising from their service in the military is not permitted to use that honorific?
Senator, I'll have to take that on notice. I will have to take that on notice. I'm not clear as to that specific.
Well, you did say, Registrar, that you thought only, or you were quite adamant about it, that the honorifics that can be used at KC or SC, you didn't indicate that there was any flexibility with respect to the policy. Is there an actual policy document that states this?
I don't have the policy in front of me, so I'd have to be... Please excuse me on that basis.
Okay. Is it possible for one of your... someone from the ART who's assisting in this to actually find the policy, whilst we're presumably it's easy to find, so we can actually interrogate this issue?
While we're doing that, Senator, I can answer the question in relation to the cost of President's Chambers refurbishment work.
Okay,
I have those figures, if that assists. So there was petitioning work done for $9,673.68 and joinery of $38,485.83.
Sorry, how much?
$38,485.83.
Joinery.
Joinery.
So is that the shelves for the library?
Yes. What I'll do, I think
so
we've answered this question.
Mr. Crew?
No, Senator, not. I think we've answered this question previously with a Quan AE24-121.
Okay. Was there, just in terms of, if you could refresh me whilst the registrar's just having a look at that policy, refresh my mind. Did that answer include travel expenses or transportation expenses with respect to furniture that was moved from an office outside of Melbourne?
No, that doesn't include the relocation costs for the other furniture from Brisbane to Melbourne.
Do you have those costs?
Don't have those costs, Senator.
Is it possible to get those costs during the course of the inquiry?
We'll attempt to, yes.
If you could, thank you. Registrar.
Yes, Senator. I have had a look at the policy and it says, consistent with the practice followed by the High Court and other courts, post-nominals, such as Australian and Imperial honours, must not be used. There is an exception for members who are barristers and who have taken silk. They may use the post-nominal KC or SC.
Was there, in terms of the development of that policy, was there any discussion in particular with members having jurisdiction with respect to veterans matters about the potential benefit of their military service being recognised and acknowledged in terms of the discharge of their duties as members? So it would seem at first blush to me that would be of some benefit to indicate the military lived experience of some of the members, especially when they're dealing with veterans issues.
But I'm not sure, Senator. I would need to check with the President as to whether he consulted with such members. May I take that on?
Senator Scar.
May I take that on notice?
Call in a moment, just to let you know.
just
We'll come back to you if we're here.
One last question on this matter. Are you aware of any members raising this issue with concern that they were previously under the AAT permitted to use such honorifics which they earned through military service and through recognition of their military service, but under the guise of the ART they were no longer allowed to use such honorifics?
No, not personally, Senator. No one's raised it with me.
So you're not. So they didn't come to you personally, but you're not aware of any issue raised in that regard?
I'm not aware of it, no.
Okay, Mr. Crew?
No, Senator, nobody's raised it with me.
Okay,
I'm not aware of it being raised with me.
Thank you. Thanks, Chair.
Thanks, Senator Scar. Senator Shoebridge.
Thanks, Chair. Just to follow on from that, of course, there would be many people in the military who would greatly appreciate coming to a wholly independent body that had no connection to the military, where they might be seeking to review decisions or the behaviour of people in the military. And in showing that your organisation is absolutely independent of the military would potentially have significant benefits for those people, wouldn't it?
And that may well have been the President's thinking. For that matter, he doesn't recognise the doctors either, so doctors don't use their titles.
Yeah, and again, because you want the tribunal to be overtly independent of the professions or the organisations that they're oversighting.
And Senator, can I say that Mr. Crew responded to the design of our new logo? It was a deliberate decision taken by us that we not use the coat of arms or Australian crest for that matter as well, to be seen that we're actually independent of the government.
Thanks, Registrar. And I too can congratulate you and Mr. Crew on finding your way through the transition. Yes.
Thanks very much, Senator. Should I say I'm pleased to be here?
Well, perhaps. That being said, the APS census survey does not make attractive reading in terms of your staff's belief, particularly in SES management. You'd have to accept that.
Yeah, I do accept that, and I think the SES needs to be more visible moving forward. During the transition period, Senator, the SES were particularly busy. We had 2 people acting up in roles. It's fair to say that staff may not have been aware in certain circumstances who the SES were, but it's certainly something I am addressing in the new tribunal, the visibility of the SES, and also our reporting of our senior membership committee, senior leadership committee meetings, having staff aware of the issues that we're dealing with and decisions being made.
Yeah, well, I could go through the numbers, but they're not good.
No, they're not.
15% below other medium-sized agencies on the question of whether or not the SES manager clearly articulates the direction and priorities. 15% below on whether or not they present convincing arguments and persuasive arguments, 19% below on promoting cooperation, 17% below on encouraging innovation, 14% below on creating an environment that enables staff to deliver their best, 15% below on ensuring that work ethic contributes to the strategic direction of the agency. This is a damning review by your staff of SES management, isn't it?
It does not make good reading, Senator, but at the same time, the timing of that survey and the transition to the new tribunal, we did an extraordinary amount of consultation with staff, almost weekly forums between either the President, myself, SES, engaging the staff in the process of the transition, engaging and consulting with the staff in the organisational structure that we ultimately took forward into the new ART. And I would like to think that the process is now well in hand to improve that position that we had.
Well, the problem is the more that management have engaged with staff, the less happy they are. It's actually got worse this year from last year on all of those. On every single indicator, it's got worse.
We're in a period of transition though, Senator. Uncertainty, involving people in the process. It was a time of uncertainty. And whilst we did our level best to create a certain an environment of certainty, it was uncertain.
Well, I mean, another way of looking at these numbers is it's not a problem. The problem isn't so much communication between the SES management and staff. The problem is how the SES management are working. And have you got a program in place to actually fix that? Not just enable better community, but actually fix this problem.
I do. We have a monthly senior management committee meeting. We have very regular subcommittee meetings of that committee. It's now a very hands-on management team. I've introduced new members to our senior management committee with new SES having been recruited. I'm very confident going forward that you will see a change in those results.
Have you taken this survey to those meetings and shown them what staff think about the SES management?
I most certainly have, and encouraged the need for SES to be more visible and to be in the registries.
Well, I stress again, it's not just about visibility. It's about pretty much every aspect of their management that they get.
It's
comparable
true.
to other agencies of your size.
Yes, it is.
Dreadful ratings.
Yes, it is, Senator, but it begins with visibility.
Outside of visibility, what other remedial action are you taking to ensure that your staff have belief in the SES management?
With our new organisational structure, we are based on a functional structure. So the SES members are now in charge of the different functions within the tribunal. They are very hands-on now with their EL2s, EL1s, and right through to all of our APS staff. As I've said, through the transition process, and we're continuing into the new tribunal, many forums for staff to participate in, more regular communication, and certainly, as I indicated before, with our senior management committee meetings, transparency about the agendas of those meetings and the outcomes.
Registrar, I might ask you to respond on notice more broadly to the survey, because I've taken you to one aspect of the survey, but on, that really deals with the leadership SES Manager Index, where your organisation comes 97th out of 104 agencies. But whether it's on the immediate supervisor level, 85th out of 104 agencies. Employee engagement, 93rd out of 104. Communication, 82 out of 104. Enabling innovation, 98 out of 104. Wellbeing policies and support, 93 out of 104. I mean, I know it's been a difficult transition period, and I accept that may in part explain this. But when you're back again when we're looking at the next year's surveys, what are you going to do between now and then to make sure you're out of the bottom of the pack?
As I've said, it's far more engaged and active SES engaging with our staff.
All right, but I just stress engagement is only one of 6 categories, broad categories, where I don't think it's unfair to say your organisation is failing. It's one of 6 categories you're trying to address.
If you like then, Senator, I will take it on notice and provide a more detailed response.
I'd appreciate that.
Yeah.
Could I move to another matter? If we look at annual reports for the AAT and now, well, we've only got AAT, but to date, we find that the number of refugee cases on hand has risen from, I think, 1,973 a bit over a decade ago in 2012-13 to over 40,500 in the most recent report. And it has been rising at a significant rate in the last few years. What's your understanding of why that's happening?
I can say off the top of my head that in the 4 months of this financial year, there has been a 99% increase in lodgements to the tribunal compared to the same 4-month period last year. I can also say that there has been a 97% clearance rate by the tribunal of protection matters in the past 12 months, which is unprecedented in the tribunal. That is in part due to the additional funding that we were provided to deal with the protection backlog, if you like. Mm-hmm. Those additional members have been able to clear matters at a rate of 1,000 a month, and we will continue to do that. We are looking at training every member in the tribunal in both protection and student caseloads, with a view to every member in the tribunal undertaking part of this caseload.
Registrar, I accept that you're at the one end of the pipeline, right? If you've had a 99% increase in lodgements, you don't have any control over that. It's whatever comes out of the pipe you have to deal with, and I accept that. Do you have any understanding of what's driving that to you? Have you looked at the caseload and tried to understand why you've had a doubling in that caseload in the last 12 months?
It's a question better directed to Home Affairs, Senator.
But, Home Affairs is one of your key
stakeholders.
Customers, sources of trouble. I don't know how you describe them, but you must have a relationship with Home Affairs.
And we meet with them.
Have you sat down with them and said, why have we had a doubling?
We do meet with them to understand the caseload and to understand to try and get an understanding of the projections of the matters coming to us. And
have they given you any understanding from their end about why you've had a doubling?
My understanding of the current surge relates to, I just forget what they call them, basically the temporary visas that were granted during the COVID period.
What, and they are expiring now and they're up for renewal, or is that?
And the department's received additional funding to process them, so that the speed of processing obviously leads to the matters coming to us.
Registrar, could I ask you to take on notice if you have any further explanation, or if you could interrogate your staff and your team to try and get an understanding from your end about what's led to this increase?
Sure.
Is the IAA now formally abolished?
It is.
And what has happened to the staff from the former IAA?
Some of them have become registrars in the new tribunal.
Yeah.
Some have joined the legal services team.
They've transferred across.
Yeah. But all have transferred across. Those that wish to come have all transferred across to the tribunal.
And when did it cease to exist?
And some of them actually became members as well.
Some of them became members.
Yeah.
Could you provide on notice which of the members were from the IAA?
I could take that on notice for you.
Yep. When did the IAA cease to exist?
13th of October.
And could you, on notice, provide the affirmation rates, or whatever data best describes how many matters were affirmed, reviewed, etc.
By the IAA?
By the IAA.
In what period, Senator?
Well, I think there's some previous data on notice from 5 years ago. So if you could do whatever the bit of the financial year up to the 13th of October was, and then the previous 4 financial years.
Previous 4 financial years, sure.
Thanks, Registrar.
Okay, thanks, Senator.
Senator Shoebridge, I'll have to share the call. Okay, thank you. Senator Scarr, do you have further questions?
Yeah, I do.
Thank you. We'll come back to you.
Thank you, Registrar, and thank you, Senator Shoebridge, for his questions. I just have some follow-ups from Senator Shoebridge's questions. And I know you took on notice that you would provide some further breakdowns. Can I just ask you whether or not it would be possible when you provide those further breakdowns to perhaps with as much granularity as you can, which will give us an indication as to the type of visa decision or the type that is being appealed against. If you could perhaps do it on a month-by-month basis from, say, 1 July 2023 to 31 October 2024, so that we get the benefit of seeing the fluctuation. You talked about the last 4 months, but obviously for us to obtain an appreciation of the change in trajectory, it's going to help us if we can look back.
Sure. I could take you through it now. I've got a table, but we'll submit it as on notice.
Okay.
Yeah.
All right. Well, whatever additional insight you can provide now.
Oh, is it? Okay. I can certainly tell you that our student visa caseload is surging dramatically. I can give you some very high-level statistics. In the 4 months of this financial year, our student visa applications are at 11,714, and that has already exceeded the total number of student visa applications we got for last year of 11,668. And in 20
months of this year, the number of student visa applications, appeals of decisions exceed the number of applications for the whole of the 12 months
year.
Ending 30 June 2024, yeah?
Correct.
Okay.
And then for that financial year, it was 11,668. In the previous 12 months, it was 1,868. So we are seeing this seismic increase.
Okay. If you could also then take on notice, if you can provide us the annual figures, say perhaps for the last 5 years, if you've got that, so we can see the trajectory on a year-on-year basis, that would be helpful as well.
Visa types?
Okay.
In all visa types? Or just
if you can,
or just those with significant growth?
Well, I think the ones where you've talked about the increase over the last the surge in the last 4 months. So you also talked about is that the only visa category where you've seen this surge?
No, we're seeing growth across a large number of visa types, but off lower bases.
Right. Okay. All right.
Yeah, but protection, as I mentioned before, the protection caseload is surging. The student visa caseload is very...
Okay. So if you can give us the data in relation to protection visa workload as well on a similar basis, that would be helpful. Thank you. Registrar, I think when you were previously before this committee when we were looking at amendments to the Administrative Review Tribunal Act, I talked to you about some comparison I'd done in terms of caseload as at 30 May 2024 of the AAT being 69,312 cases, and then there was this blowout to 30 September of 82,417 cases. To what extent is that blowout explicable by reference to that surge you've just referred to, and what other elements were at play there?
Are you able to repeat those numbers for me, Senator? The end of May number?
So the numbers I had were end of May, 69,312.
Yep, and the other number you quoted?
30 September, 82,417.
So that's about 13,000
Correct.
on my numbers. So we can say at least 11,714 of those are student. We also had a surge. Have you got the June number there?
No.
For students?
Not for students.
I think there were about 3,500 in June alone. I will... Yeah, 3,469 as well. So just that caseload alone gives you the difference between those two numbers.
Okay. Similarly, when we compare the position of one of the indicators of efficiency of the AAT as at the end of May, the median time to finalise a case was 38 weeks. 56% of cases were finalised within 12 months. At 30 September, the median time had blown out to 55 weeks and just 49% were finalised within the 12-month period, so less than half. Can you explain why there was that change?
I think I gave you an incredibly good answer last time, Senator, and that I explained it that...
I'm going to compare the answer you gave me last time to the answer you're giving me now and see if I can see any differences, Registrar.
Hansard. Senator, we were given 116 members who addressed the protection backlog, and we addressed it from the back. So we had matters that were 7 years and 6 years old. So as we calculated the numbers and the averages there, because we were dealing with such an aged caseload, the average time from lodgement to finalisation naturally blew out because of that particular caseload those members were dealing with. And as I said before, they were dealing with matters that were about 1,000 a month.
Okay, so
Senator, as I think I jumped in last time, to ensure Hansard's the same, it's of those cases finalised in that period, it calculates the time rather than the cases on hand. So when you're attacking the back and the oldest cases and finalising more of your older cases, the time that's reported changes. So as a consequence of us going to the ART and looking at what our performance measures will be so that it actually makes a little more sense, we are looking at things like the time for the cases on hand. So what is the age of the cases on hand, still waiting to be heard, as a performance measure, rather than saying focusing on the front end and having a very good timeliness figure, even though your cases are getting older. So we're looking to improve the way we report on those figures for the ART.
So what's the process of doing that, Mr. Krill, in terms of developing KPIs, if I can put it that way, that provide more transparency, enable interested stakeholders when they're pursuing the annual report of the ART to gain a reasonable and clear perspective as to performance so that we can compare year on year performance? So
first and foremost, Senator, we're looking at what our objectives are in Section 9 of the Act and then designing performance criteria that measure those objectives. And I hope that before we, certainly by the time we lodge our corporate plan, which will be early next year, we'll have in place some performance measures that will enable you to properly analyse our performance.
Okay. What's the process to do that, Mr. Hawkins?
Senior Membership Committee, the Tribunal Advisory Committee, which is the President, the jurisdictional area leaders, ourselves, will all be looking at what can best measure our performance.
Okay. Can I ask whether or not there's been any change in relation to the publication policy, publication of decisions of the ART when you transitioned from being the AAT to the ART? Was there any change in policy as to what decisions of the ART should be published?
Yes, there has been, and you'll probably see that in a performance measure. Never have been convinced that just publishing a certain quantum of decisions lends anything to our transparency. We're certainly motivated by the findings of the Robodebt Royal Commission to ensure that we are publishing decisions that are of significance and that will give people a guide as to what types of decisions are being made and what they might expect.
So you recognise there's a public good in terms of the publication of decisions of the ART?
Yeah. Yes, and that's why our decision-making policies will be more qualitative than quantitative.
Right. But why is it your view that too many decisions were published?
Oh, no, not at all, but I'm more concerned about ensuring that we publish decisions that are a higher qualitative nature than purely a number.
Right.
Otherwise, you could end up publishing 2,000 decisions because you have to publish 2,000 decisions. I'd rather publish 500 that are meaningful decisions.
Okay. So since the ART started operation, how many decisions have been published?
Well, I think we're only into our 45th day. I'm not sure that we've got any published on AUSParliament yet, but we will have very soon.
So is there any have any presumably decisions have been made in that 45-day period, is that correct?
That's true.
How many decisions, if just a ballpark figure, have been made in that period? Do you have the figures, Mr. Crew?
There have been 14,000 finalisations, Senator, but they could be a mix. So that would be the maximum number that could be decisions. 14,000.
But not a single decision's been published yet on AUSParliament.
So, Senator, one of the reasons for that is the technology work that's occurring to get the tool that we use to transfer decisions to AUSParliament for publication is almost complete. And that has created some of the delay in actually being able to publish decisions to AUSParliament, the technology aspect. And we're working through the process at the moment of how the decisions that are significant decisions, and there is a decisions publication policy that sets out the criteria for decisions that will be published, how we actually get those decisions to be published. At the moment, for much of the decisions, they're randomly selected for no reason, just to hit our 5,000 figure.
Right. So,
do you mind if I just take Mr. Crew's finalisations number on notice? I think the number we cited there is decisions made since 1st of July.
Yes.
As the AAT and ART. We haven't done 14,000 decisions in 45 days.
That's the 4 months to the 31st of October, Senator, sorry.
Okay, so that only covers 17 days of October. Okay. Registrar, were you aware of the technology issue?
Oh, we have a lot of technology issues at the moment, Senator, so no.
Oh, do you? That's going to lead to an obvious next question.
No, it's consistent with the answers I've given you in the past. Our case management systems are somewhat out of date, and we are very grateful for the funding that the government has given us to build a new case management system.
I have to share the call with Senator
happy to
Ghosh
share
for
the
a
call.
moment while we have time to come back to you. Senator Ghosh, you have a few questions.
Thank you, Chair. Thank you, Registrar and the witnesses. That's an opportune time because my questions relate to your case management systems. In my experience, they can be a source of efficiency and a source of great misery as well. And I understand that the AAT and the ART run, or the AAT did and the ART now runs some pretty dated and what might be termed legacy case management systems. And I understand that that's as a consequence of the amalgamation in 2015 and bringing a number of different systems on board when it was the AAT. How many of these systems are there, and are you able to tell us sort of how old they are?
We have 3 systems in operation at present. I can tell you that all of them are past their end of life. In the ART, we have a new system for the Guidance and Appeals Panel in our new case management system, and we will progressively move over the course of the next couple of years to move all of the legacy systems across to the new system.
Do you have any feedback from your staff about how they feel about the current case management systems?
Yeah, it's we have a lot of feedback, and you can have a look at our census results, and we have workplace health and safety issues.
Are you able to characterise that feedback just briefly and then expand on health and safety issues that you're referring to?
Yeah, we've got one system in particular that only enables 40 users at a time to use it, and we have a lot more users that need to use it. So staff are waiting, they're stressed about the downtime that they're forced to endure to get matters out. We are aware of that. We've got a rostering system at present to roster staff on to be able to use the system. Terribly inefficient. We have staff working overtime. By design, it's, from our perspective, completely unsatisfactory. But it is a system that we're working now to move very quickly to get one of our caseloads off that particular case management system and onto the new one. And we hope to be in that position at the end of March.
So if you've got a rostering system where you can only have 40 users on time, and that's across the whole tribunal?
Across the whole tribunal. But okay. It's only in limited caseloads.
Okay. I'm assuming then that that's effectively a choke point, so it slows down your ability to get through your caseloads and
it requires careful management, Senator, yes.
So why weren't these updated in 2015?
One is always cautious to question the shoes that one's predecessors were in. I don't know what their prerogatives were at the time. I don't know what their funding arrangements were at that time, Senator. But one thing I can say is that the particular system we have that gives us the most problems didn't have one caseload on it, and that was added in 2015 in the NDIS. And as you know, you're aware, Senator, we do have a very significant caseload in the NDIS over that period of time. And I think that's added to a case management system that clearly didn't have the capacity, nor was it foreseen at the time of its development that it would ever carry that size of caseload.
Now, I understand that there was a pilot in 2021-22 for the AAT to develop a consolidated case management system. Are you aware of that?
Before my time, Senator, I would have to take that on notice. Are you aware?
Senator, yes, there was a pilot in 21-22 in order to test which system we would go with, and we've gone with the Microsoft Dynamics system, and that was as a result of that pilot that was undertaken. Then we commenced working on the new CMS after that pilot. Once we received the funding, one of the challenges at that point was we were running deficits, we had no money. We did the pilot anyway because we had no choice. And we then received the funding for the new CMS program and were able to commence the work at that point in time. And we were able to deliver the Guidance and Appeals Panel program as part of that new CMS program for 14th of October, and were able to learn significant things from that process, and are now in a position and are working very quickly to try and get our next caseload onto that system to alleviate what are unacceptable challenges with our existing case management system.
If you don't know, that's fine, but were the issues with the case management system communicated in that period from 2015 to 2022?
So I think I arrived in 2021, I think, Senator, and at that point staff had heard about the case management system, and still to this day, until they see it, some of them not sure they're going to believe it. So it's been talked about since 2015. Now that there have been some staff exposed to the product with the Guidance and Appeals Panel, we are starting now to create some momentum for the system.
So it was, sorry, Registrar?
I was going to say, and the learnings that we've taken from the Guidance and Appeals Panel are positioning us well for each new case management system that we add to it.
And can I take from your answer that this is one of those notorious systems about which people talked because of its inefficiency or its lack of usability?
Absolutely. So it doesn't have vendor support. We don't have the code for it. It can only do one transaction at a time. And the caseload in that system and the number of users on that system has increased exponentially. So it just cannot support it any longer. So we are working as quickly as we can to get off that system.
My stress levels are rising listening to your description of it, so I can only imagine what it was like to use. Now, I understand that in the 2023-24 budget, you were provided $11.7 million to develop this new case management system and a further $17.9 million in the 23-24 MyEFO, so that's, give or take around $30 million. Are you able to tell us how close you are to implementing it or if it's implemented already?
I think that 29 million has been given, or 29.6 has been given to us over 4 years.
Okay.
We're nearly halfway through.
We're partway through, but we've only spent a small proportion of that amount of money for a variety of reasons, including being able to access experienced technicians, IT people. The labour market over the last couple of years in that space has been challenging. So we've burned a little bit more time, but we haven't spent the money. We've also had to divert resources away from that program to see if we could salvage anything with our existing system to improve it in some way. That delayed us a number of months because while we said we'll never be diverted, we had to be diverted. So we hope to have a caseload on by mid-next year, and the way that we have structured the system, and the approach to the system is to get off the existing systems first, not to build the final product. So it's not going to be the end product that we roll out. We're going to implement a minimum viable product to get off the existing systems. The second part of the program will be about gaining efficiencies and productivity. And we are confident that once we get a bit more cadence happening in relation to the program, we will start to move very quickly.
I was very committed to us not spending one more cent on any of the legacy systems, but we've simply had to, as Mr. Cruz said, we've had to divert resources away from it. We've also had to divert time, which has been a real disappointment. I say, sorry, a disappointment in the sense of being able to advance the new case management system, but certainly not a disappointment from us looking after our staff.
And I appreciate you might not be able to give this in precise terms, but what do you anticipate in terms of productivity or efficiency gains, both when you get onto these new minimal viable systems and then also the new case management system?
Well, the goal at the moment, Senator, of getting off the existing ones is to get through a day's work in an appropriate amount of time. That's where we're at right now. An application that was taking 15 minutes is now taking an hour. So that's the sort of challenge that we've got in that space with the system at present. So we will create efficiencies. We will leverage the technology as it's supposed to be used. As to actual efficiencies, we have some percentages built into our forecast for years 3 and 4 to be gained of a few percent in relation to financial savings, but it's really about getting through the work quicker is the benefit, and accessing information more readily. So the accessibility aspects of the case management system, where people will be able to look up their own information, find out when their matter's on, where it's up to, what the documents are, for example, rather than contacting us, and they'll be able to do that 24/7.
But the most important efficiency will be our staff wanting to use it.
Well, look, I'll finish on this note, which is to commend your staff and your members for having used a system that sounds like it was both dilapidated and underinvested in over a very long period of time. And I hope the new one goes well. Thank you, Chair.
I'm sure on behalf of my staff, Senator, we thank the government for the funding to give us a new case management system.
Thank you, Registrar.
Thank you, Senator Ghosh. Senator Scarr.
Thank you. And that's very polite of you, Mr Registrar, to thank the government for that funding. And
Sounds like they were waiting a long time.
it was very strategic to always be thankful, Registrar. Can I ask you, in relation to publication policy, so as I understand your answers, there's a difference in approach now. The intent is there is a difference in approach between what the approach was under the AAT to what the approach is now under the ART. Is that correct?
That's correct.
And you talked about the approach being to publish decisions more on a qualitative basis rather than a quantitative basis. So what's the hallmarks you're going to be assessing? What are the indicia that you're going to be applying in determining whether or not a decision should be published based on your more qualitative approach?
Senator, may I take that on notice and actually provide you with the policy?
Sure. You don't have it there now?
No, I don't, sorry. Let me draw a bit of speed reading of the policy. There is no 3.6.
Senator, perhaps I can read out the selection of decisions for
Sure.
publication. Subject to paragraphs 4 and 5, which my numbering seems to be a little bit odd in this document here. Publish all decisions in relation to the following categories: Guidance and Appeals Panel, Tribunal Guidance Decisions; the Guidance and Appeals Panel, any other decisions to affirm, vary or set aside the decision under review; significant decisions regarding conclusions of law or implications for Commonwealth policy or administration as identified by the President; decisions made following a court remittal where the original tribunal decision was previously published; and publish decisions from the 8 jurisdictional areas that satisfy one or more of the public interest criteria as outlined in paragraph 3.2, as selected and approved by the jurisdictional area leader or list leader. In order to satisfy the public interest criteria, decisions should meet one or more of the following criteria: provide insight into and or are representative of the conduct of reviews for the jurisdictional areas, show how the tribunal interprets and applies the law and policy, involve novel fact situations or issues of law, reflect a range of outcomes and members. Its contents may assist members in dealing with similar cases.
Right. So one of the categories you mentioned there was significant decisions, and as I understood it, it's significant decisions as identified by the President.
Yes.
So under the previous, when you were the AAT, did the President have a role in determining what decisions were published or not published?
I would need to take that on notice, Senator.
So there is a policy as well, Senator, in relation to significant matters that are to be referred to the President for consideration, where either a staff member, a registrar or a member may refer a matter they consider as a significant matter based on a set of criteria. I don't have that policy at my fingertips today.
But here we're talking, sorry to interrupt you, we're just getting to the end of our time, but here we're talking about significant decisions as opposed to significant matters, and I can understand why significant matters, however that's defined in the policy, might be brought to the attention of the President, but here we're talking about decisions which have been made. It just seems a very bureaucratic process from my perspective for the President to have to make decisions as to whether or not a decision is of such significance that it should be published.
I think, Senator, it's on the back of the significant matters, and if those matters are referred to the President, then what flows from the significant matter would be a significant decision. So if the...
Sorry to interrupt again, is that the intention of the drafting? When you refer to significant decisions, you're talking about decisions in relation to significant matters which had previously been referred to the President?
Yes.
But I understand the President may also delegate that power to jurisdictional area leaders or list leaders as well, Senator.
Okay. And could you take on notice as to whether or not any of those delegations have occurred?
Sure.
Mr. Registrar, we're talking about current vacancies, staff vacancies, and you referred to 40 to 50 registrar positions, 40 to 50 other staff positions.
Member support staff, yeah.
Sorry?
Member support staff.
Yep.
Yep.
How many staff left? Presumably you're keeping some pretty intensive records in relation to transition issues. One of the transition issues, knowing how thorough you are, you would have been considering is the success or otherwise in terms of staff transitioning from the AAT across to the ART. Can you give us any figures with respect to the percentage of staff who actually transitioned from the AAT to the ART?
Not at my fingertips, Senator, and I'll take that on notice, but I'm not aware that we have a significant number of staff that left.
Okay, if you could take that on notice.
I will.
Do you have any figures in relation to the number of staff who've left since you were reconstituted as the ART?
In the last 45 days, I will take that on notice as well.
Okay, thank you. During the last hearing, my colleague Senator Cash referred to, and this was with the department, not with you, Registrar, but she referred to, Senator Cash referred to some tweets or social media which had been broadcast by the now Deputy President Thompson prior to her becoming Deputy President. I note that. Are you aware of whether or not there's been any discussions with Deputy President Thompson in relation to the previous publication of those tweets or social media posts and what is or is not appropriate now that she is Deputy President?
Yes, Senator. Certainly the events of the last Senate hearing were brought to my attention and I duly brought that to the President's attention. That took place on Tuesday the 5th of November. On Wednesday the 6th of November, the President wrote to that Deputy President and asked her to confirm whether she was the author of the tweets, whether the account from which the tweets were made was closed, and if so, when, and the nature of her present social media presence. The Deputy President wrote back to the President on that same day, confirming that she did not check all the tweets, but the two she checked were sent by her from the Twitter account in her name, and it was very likely that all the others were also sent from her account. She closed the Twitter account prior to November 2023. Her current publicly available social media activity is limited, and she only posts innocuous material. Since her appointment to the AAT in July 2024 and the ART on the 14th of October 2024, she has taken steps to ensure that she does not say anything that may be regarded as controversial or damaging to the reputation of the AAT or the ART, and she will continue to be extremely careful about what she says and how she uses social media. She gave the President an assurance that she will not use the sort of language that she used in the tweets that were tabled in Parliament in any public or work setting, and she will do her absolute best to not breach the social media policy, which she has read and understands. And based on that information that the Deputy President provided, the President formed the view that the tweets that were tabled in Parliament were posted prior to the establishment of the ART on the 14th of October, that the commencement of the Code of Conduct for non-judicial members was on the 14th of October, and as the Code did not have retrospective effect, it was not considered to be a breach under the Code.
Are you reading from
What
are you reading from there, Registrar?
From my notes, from an email the President sent to me.
Okay. Could I ask you to table that, please?
Sure.
And can I ask you also to provide on notice a copy of the correspondence or correspondence which transpired between the President and the Deputy President in relation to that matter?
I'll take on notice whether it's appropriate to disclose correspondence between the President and a member, but if it is, I will certainly do that.
Okay, well, it's a question of whether or not the Minister or the Government elects to take a public interest
Correct.
Immunity claim. So
That's right.
I'll leave that to the Minister, but I'm quite happy for you to take it on notice.
Yep.
And any other documents or records you might have in relation to that interaction between the President and the Deputy President in relation to her use of social media, you can take that on notice?
I will.
Okay, thank you. Were you present at any meetings between the President and the Deputy President? Were there any telephone conferences or meetings?
I was not.
Okay. Has any communication been made to other members of the ART in relation to social media use after this episode?
Not after this episode, but there was certainly extensive discussion of the Code of Conduct at the member induction program that we had 15 and 16 of October.
Okay. Secretary, during the course of the last estimates, there was questions raised about the recruitment process and in particular issues around disclosure of sensitive issues, perhaps as part of the recruitment process, whether or not applicants were required to provide information of anything which they believed should be disclosed as part of the recruitment process on the basis that it might prove embarrassing or controversial in any way. And the department indicated at the time that it was not aware through the recruitment process of these social media posts. Do you have anything further you can share? Has the department looked further into why it wasn't aware of these social media posts during the recruitment process? And has the department also looked at whether or not there was appropriate disclosure during the course of the recruitment process by the prospective candidate?
Thanks, Senator. Following the hearing, I had initiated some inquiries in terms of our general process as well as how it specifically was applied in those circumstances, and I'll need to check, but I believe we also took some questions on notice about that, which we will be in the process of finalising. So I don't have specific details to provide to you here today, but if there's beyond what we've already been requested to provide in terms of an answer to a question on notice, the specifics of what you're asking now, I will take on notice and seek to provide.
Were you aware that the President and the Deputy President had engaged in the process that the Registrar just outlined in relation to that social media?
No, Senator, that's the first I've been made aware that happened.
Okay. As part of your processes, you referred to looking at the issue as to why perhaps it was not discovered as part of the recruitment process. Is the department also looking at whether or not appropriate disclosure had been made by the candidate during the recruitment process?
There's a couple of steps that are relevant here. There's the recruitment process, and then there's the disclosures that are required when any candidate for a statutory tribunal or judicial appointment is put forward to Cabinet, and we call it the personal information disclosure. So in that context, so there's two aspects, and we've taken that on notice, I think, but I should clarify that. I'll need to check, but I don't have any specific information to provide to you now.
Okay. Well, just for the sake of the record, if you can look at both, provide advice to the committee, provide any documents in relation to the process the department has undertaken since the last estimates in terms of looking into investigating, firstly, why, as part of the recruitment and assessment process, the department itself didn't locate, identify those social media posts. That's the first link.
We don't know if they didn't.
And
we don't know if they didn't. You know what? Yeah.
Sorry?
The Secretary has taken a series of questions on notice at the last estimates, and the presumption in your question is that information wasn't located. Obviously, throughout that process, there's a number of things that would be put forward that might include social media posts. It might include that they were a former Liberal Senate candidate, but the Secretary has taken that on notice, so she needs to answer those questions before you're able to determine what and wasn't considered in that process.
Well, sure. I'm simply... there might be some duplication, but I'm sure the Secretary is able to deal with that. So the point is, we're looking at both the department's processes in terms of identifying social media posts, and then the second limb of it is what actions, what investigations, what documents have been created by the department, and I ask you to take on notice to provide any documents of that nature in relation to consideration by the department as to whether or not appropriate disclosure was made by the applicant during the recruitment process. Is that something you could take on notice?
Certainly I can, in addition to what we've already taken on notice, and as I said, I can't remember the exact specifics, but I do think there was a long line of questioning, and I think I took on notice quite a few things along the way. So certainly we will be responding to those questions, and we will seek to respond to the questions you're just asking there. The reason I'm pausing is you said you referenced creating documents, and I'm just not sure if any documents have been created.
I'm asking you to take on notice to provide any documents that have been created since last estimates by the department in the course of looking into those issues.
I'm happy to take that on notice.
Thank you.
That's all the time we have, Senator Scarr. Thank you.
Chair, if I can answer one of those questions, if now's time, or
if you can do it in like 15 seconds.
Transport costs, Senator, $840 to transfer 2 single lounge chairs, 1 2-seater lounge, 1 coffee table, and 2 visitors' chairs.
Great, thank you. That concludes today's proceedings. I thank the Minister and the Secretary and Department of Officers for their attendance, as well as Hansard Broadcasting and the Secretariat staff. Senators are reminded that written questions on notice should be provided to the Secretariat by Thursday the 5th of December, 5 p.m, and answers should be returned by Thursday the 16th of January. The hearing is now adjourned.